I do, Your Honor. 5 minutes, please.
5 minutes, please. Thank you.
May it please the Court, Your Honor, my name is Renee Hammond, and I, along with Mr. Stephen Ross Johnson, represent the appellate, Mr. David Lynn Richards. Your Honors, Mr. Richards' wrongful convictions arose from allegations of sexual abuse levied against him by his adopted daughter, AMR, more than a decade ago. Allegations that Mr. Richards has steadfastly denied from the time they were made all the way through his testimony at trial. At that trial, the state's proof consisted of 3 key categories of evidence. The opinion testimony of former TBI agent Amory Cannon that her serological and DNA testing had conclusively established the presence of Mr. Richards' semen and his DNA on a drawer in AMR's bedroom. Other evidence, and particularly argument by the state, that Mr. Richards alone had the ability and opportunity to wipe clean cell phones belonging to him and AMR after trial, after his allegations against him were made. And finally, AMR's testimony, which went essentially unchallenged at trial. These 3 key pieces of evidence work together to bolster AMR's credibility, to prejudice Mr. Richards' credibility, and ultimately to support Mr. Richards' convictions. Evidence gathered after the jury verdicts in this case, however, established that the state failed to disclose prior to trial that Amory Cannon had in fact resigned rather than be fired from the TBI for on-the-job misconduct that included reporting results for testing.
I don't want to stop you, but your brief was very thorough. So I want to make sure I'm clear on certain facts, and it sounds like you're going through them in your upload to the argument.
Yes, ma'am.
But when did the state become aware of, is that fact known, of the TBI, is it TBI?
TBI.
Of the forensic analysts, I guess, misconduct? When did the state become aware of that? Is that fact known in the record?
The state, it's the TBI. The TBI is this because TBI was a law enforcement agency.
I understand.
Yes.
Under the big rubric, she is, or a part of the state. But do we know if the prosecutors who prosecuted this case became aware of this information? Do we know that fact?
That is not entirely clear in terms of timing. There was some evidence that they knew that she didn't just move on to greener pastures.
What is that evidence?
Well, Ms. Kuykendall, who had assisted trial counsel, testified at the hearing on the motion for new trial that she thought that somebody might have told them that Ms. Cannon left for greener pastures, but she wasn't sure. Maybe it was something else. She couldn't remember. It wasn't entirely clear. But Your Honor, I would argue it doesn't actually matter when that prosecutor became aware of the information, because the TBI is a state law enforcement agency.
I'm a former prosecutor. I know that the state is, responsible for all of that information. I just didn't know, based on the voluminous amount of information that's in both parties' briefs, whether that came out. And I didn't mean to interrupt your factual flow. You can continue.
That's fine, Your Honor. Ms. Cannon's misconduct was not just timekeeping, problems with her timekeeping. She was actually recording test results when she wasn't even in the building. And so this was evidence that is absolutely irrevocably damaging to her credibility, a fact that the TBI knew and said it just that way. We're going to let you resign in lieu of termination, but you have to go because you're no longer credible. And The state also failed to, or the state was allowed to argue at trial that Mr. Richards alone had the opportunity and the ability to wipe these cell phones clean. But the reality was that anybody who had the login credentials to this shared Apple iCloud account could have wiped these phones clean, including AMR. And moreover, Andy Sporer, forensic electronic evidence expert, testified at the hearing on the motion for new trial that the phones were wiped clean at a time when Mr. Richards did not have access to any of his own electronic devices, but AMR not only had access to hers, but was using it. So had that, even though the trial counsel got the state's forensic guy to admit he didn't know who had wiped the phones or when they had been wiped, the state would not have been allowed to argue that Mr. Richards was the only person who could do that had trial counsel hired an expert and had this new evidence about the timing of when the cell phones were wiped and how that actually worked. Trial counsel admitted at the hearing on the motion for new trial that all he knew how to do on his cell phone was call the numbers that his administrative assistant put in for him. So he didn't make any effort to try to understand that information, and as a result, not only did this not only was the jury left with this misleading impression, they got an adverse inference instruction, which was absolutely damning to Mr. Richards' credibility.
So when the case was tried, the jury never heard when this cleaning of the cell phones, when they were swiped.
That's correct, Your Honor.
They didn't know when that occurred.
They didn't know when that occurred. What happened was Mr. Richards' cell phone was seized from his home along with his other electronic devices, and then about 8 hours later or so, AMR's cell phone was seized.
Right.
And the Knox County Sheriff's Office, instead of putting these in airplane mode or put them in a Faraday bag, just turned them off. And so the way this works, if you have an iPhone, you can get on the Find My iPhone and reset it to factory settings remotely if you have the login credentials for a shared iCloud account. And so what happened was, as soon as James Smithart, the expert at the Knox County Sheriff's Department, powered those devices on, they reset to factory settings. So that happened sometime in 2017. But Andy Sporer was able to go in and use Celebrite technology, which I'm sure your honors are familiar with from having read other records, and see exactly when those phones were wiped. And to show, additionally, at the hearing on the motion for new trial, there's a portion of the forensic interview that was admitted at the hearing on the motion for new trial where AMR said she was looking on her phone last night for pictures of Mr. Richards. So that showed that she was using and had access to, contrary to some evidence that came in at trial that her phone had been taken away from her by this family friend, she actually had her phone and she was actually using it at that time. And then, Your Honors, in about a minute here, the state also didn't disclose, AMR had been in and out of DCS from the time she was 3 until she was adopted by Mr. Richards as she was a teenager. That's thousands of pages of DCS records. And in those records, and Brady applies, it's limited to DC in the terms of DCS records, but Brady does apply, but the state failed to disclose. AMR had mental health diagnoses, including psychosis, that seriously impacted her ability to perceive and relay accurately events at the time of the alleged offenses, at the time of trial, which trial counsel could have used to impeach her credibility by impaired capacity under Rule 617. She had also, in those DCS records, made a previous unfounded allegation against an older sibling, which could have been used to impeach her credibility, as State v. Wyrick tells us, under Evidence Rule 608B. For all these reasons and the reasons laid out more fully in our very extensive, as you said, Your Honors, briefing, we believe that this court should reverse the convictions and allow Mr. Richards to have a trial at which all of this evidence is presented to the jury so that the jury has the tools that it needs to make an accurate determination of the credibility of the witnesses and accurately assess Mr. Richards' guilt. Thank you, Your Honors.
Thank you, Counsel.
Thank you. All right. You still got your rebuttal time, too. Certainly. Good morning, General.
Good morning, Your Honors. May it please the court. Alan Groves on behalf of the state. The jury believed you, and I believe you, and I still do. Those were the words of the trial court on the last day of the motion for new trial hearing, after hearing all of the new biological, cell phone, and impeachment evidence. And I want to start with that because I think that credibility determination must inform this court's prejudice analysis when it considers the three major claims that the defendant has asserted: that he's entitled to a new trial based on newly discovered evidence, ineffective assistance of counsel, and then the materiality analysis of Brady. That credibility determination has to inform the prejudice analysis for all three types of claims. That's very important to emphasize. I also want to correct a couple of counsel's characterizations of this new evidence. First, counsel stated that Ms. Cannon testified that the biological evidence conclusively established the presence of Mr. Richards' semen. That is not what Ms. Cannon said during the trial. There were several questions by the state, and as we all know, we're attorneys, we're not all medically trained, and sometimes our questions are inartful. But there were several questions where the state was trying to get Ms. Cannon to say that, or to see if that was what her testimony was. She never said that, though. She consistently testified that she was sure that Mr. Richards' DNA was in the non-sperm fraction of the sample that she tested. She never made the connection that conclusively established that meant the semen belonged to him. There were other ways that his DNA could have ended up in the sample, such as through touch DNA and things like that. So that's one correction I wanted to make.
Argue that, though?
I'm sorry, Your Honor?
Did the state make that argument or inference from? I guess what I'm trying to, it wouldn't be relevant if the sperm wasn't, or the inference that there was some sort of sperm in the DNA. I'm going to butcher the terminology as well. But was the inference made in the argument subsequently?
The prosecutor did rely on the presence of Mr. Richards' DNA in the victim's bedroom to support its theory of the case, but the jury had to assess that evidence and weigh it properly. So that really goes more towards weight. But Ms. Cannon's testimony itself was not misleading or inaccurate. And in fact, at the motion for new trial hearing, Ms. Cross, who was the defense expert that was brought in, she admitted in her own reports that what Ms. Cannon testified was technically correct. She admits that in her own report. The second thing I wanted to...
Was that at the motion for new trial when that
Yes, Your Honor.
evidence came in? The expert for the defendant you just mentioned? Okay.
Yes, Your Honor.
Not that the jury didn't hear any of that, though.
Correct.
Right,
The defense experts all testified at the motion for new trial hearing.
Okay, I'm sorry.
I want to go back to, I think, what Judge McMullen was getting at. So there was DNA evidence of the defendant on a drawer or something like that in the victim's bedroom.
Correct. It was a drawer attached to the bed.
But there was no evidence that within that DNA there was the defendant's sperm.
So Agent Cannon observed sperm in one of the extractions. There were 5 to 10 sperm heads, but she divided out the sample into a sperm fraction and a non-sperm fraction.
And there's
the
a
DNA
chart in somebody's brief, I think, that sets that out. Okay, go
Yes,
ahead,
Your Honor.
I'm sorry.
And the DNA was only found in the non-sperm fraction. And my chart's on page 37 of the state's
Okay.
brief.
Okay, so say what you just said again.
The defendant's DNA was only found in the non-sperm fraction of the sample that Ms. Cannon tested. And that was very clear at trial.
So why was it the fact that his DNA was on this drawer, and if I understand what you said, there was no evidence that there was sperm in that DNA. Is that right?
Can you restate the question?
There was no evidence that there was sperm in that DNA that was found on her drawer.
There was evidence that there was sperm in the sample on the drawer, yes.
Okay. Okay.
Okay, before you go on, just to kind of, what was concerning to me is the misconduct or the withholding of the misconduct regarding this particular witness. Can you kind of get to that? How much the state knew, when the state knew, why it was not released? Because you put a witness on knowing that the witness, or talk to me about that.
Sure, Your Honor. I agree with counsel that the record is not clear when the state first learned of this evidence. And by the state, I mean the prosecution. I think that's important to make that distinction for the Brady analysis. But it is true that at the motion for new trial hearing, Ms. Kuykendall and Mr. Harrison testified that they had this vague recollection that perhaps either the TBI or the prosecution had informed them that Ms. Cannon had left the TBI, but they weren't sure. Mr. Harrison even said, like, maybe I called the TBI to ask about that. I just don't remember. So that's the extent of the testimony that we have about when the prosecution learned about this. But just for timing purposes, I do want to kind of lay out a little bit of a timeline with respect to that, because this case is a little bit unusual in that the investigation took a very long time. And I think so the forensic biology report that Ms. Cannon actually prepared was prepared in November of 2014. Mr. Richards was not indicted. The presentment was not filed until almost 2 years later, in August of 2016. The misconduct was about a year before the presentment. And Ms. Cannon actually resigned about 6 months before he was even charged.
But she testified in this case.
She did
regarding her
testify in
findings.
this case. But I don't think...
And so she resigned before the trial, correct?
Yes, about 6 months before. Well, about 6 months before the presentment, well before trial. I think trial was February 2019.
And your brief was extensive as well. I want to give you credit as well. I read them both, but for purposes of argument, I do appreciate you kind of refreshing us in terms of what is in your brief. So I appreciate
Sure.
that.
And I apologize for the length. I'm just trying to respond to the issues.
No, I think this case deserves it. Both parties did a really good job of laying out everything, so.
Sure, and I'll just elaborate a little bit more on this TBI issue. So first, with respect to all of the newly discovered evidence claims, for one, I think the court can pretty easily set aside the freestanding newly discovered evidence claims. The defendant basically makes no effort to argue that they were reasonably diligent in presenting this evidence. Really, they put most of their eggs in the ineffective assistance of counsel basket. And I want to push back pretty hard on their contention that the state can't have it both ways in this regard, because their argument is, well, if we weren't reasonably diligent in presenting the evidence for purposes of the newly discovered evidence claims, then that per se means there was deficient performance for the IAC claims. And I reject that argument, because obviously if the defendant is making a strategic decision not to put on that evidence in the trial, then there's no deficient performance because there was a strategic decision. So we can absolutely have it both ways. But with respect to whether there was deficient performance in failing to discover Ms. Cannon's TBI investigation, I don't think that there was, and I want to make 2 points on that. First, Mr. Harrison made it pretty clear that his trial strategy depended at least in part on using Ms. Cannon to the defense's benefit, because most of her report was actually, either favorable or at least neutral to the defense, because she had a lot of results that were just inconclusive. There were a lot of things that she tested that just did not produce any DNA results, and he wanted to emphasize that. From my read of the transcript, it also looks like the defense had some kind of demonstrative aid that they used for the jury and was putting big zeros in each category where the report did not produce any evidence. So it wouldn't have made sense to really attack her credibility, or at least that's kind of the strategy that Mr. Harrison took. Because he was wanting to use her testimony to draw out some of these good things in the report. Second, Even putting that aside, this court has repeatedly said we do not bring our hindsight to these types of issues. And so all Mr. Harrison knew before trial was that Ms. Cannon had left the TBI. People change jobs all the time. That inherently doesn't suggest that there was some kind of misconduct involved, that he should have been probing a little deeper to figure out what the circumstances were. We only, this issue really only comes to the forefront because we have the hindsight now to know what actually happened. And the state acknowledges that, that evidence is favorable to the defense to some extent. But we can't use that to make that threshold determination that there was a deficient performance when we only know that because of hindsight. And furthermore, I want to address the prejudice or the materiality for the Brady claims. I think the TBI file is not prejudicial for two reasons. One, you have to consider the nature of the misconduct that was being investigated. We had in January 2016 two timesheets that were pre-filled out and submitted where Ms. Cannon said that she forgot to go back and correct the amount of time that she worked. Two discrete acts of filling out timesheets. And Ms. Cross, the defense expert, even admitted, I'm not very concerned about that. Like, that's not as concerning to me as the incorrect dates on the case notes, which, again, only were found in like 1 or 2 months, I think, December 2015, January 2016. And Ms. Cannon, when she was being investigated for this, took responsibility and said, yep, those were errors. I'm not sure how that happened. Those were my mistakes. I take responsibility. But I don't think, I will spot them that this goes to credibility, but I just don't see how a reasonable juror looks at those types of errors, the nature of those errors, and concludes that this forensic scientist completely fabricated the lab results in this case. I mean, if that was her intent, she didn't do a very good job, because the only thing linking to Richards at all was the DNA and the non-sperm fraction. So if you were going to fabricate something, why not say that you saw DNA in the sperm fraction? There would have been a lot better ways to frame Mr. Richards if that's really what was going on. The second reason I don't think that this type of evidence is very prejudicial, or at least that it didn't affect the outcome of the trial, is when the errors occurred. Just getting back to the timeline, Judge McMullen, the misconduct occurred a year after, over a year after she prepared her forensic biology report in this case. So I think it's kind of a stretch to say that because she did this at one point, that invalidates everything she's ever done in her career before that. Maybe if it was a little closer in time, or if it was related to this case, where we had case lab notes in this case that had incorrect dates, I might have a different argument here on that. But given the nature and the timing of those errors, I don't see how that had a reasonable probability even of affecting the outcome of the trial. Just sticking with the biological evidence a little bit, I want to emphasize that the defense expert did not dispute that Ms. Cannon saw sperm on the slide, and that was pretty important evidence. She even admitted that the amount of sperm that was observed was consistent with someone who had had a vasectomy, because there was only 10 to 15 sperm heads. And the state acknowledged in our brief that Mr. Harrison was incorrect about how he understood the effects of a vasectomy, but that's really entirely irrelevant in the end, because the defense's own expert, who, if they had called her at trial, would have got on the stand and said, yeah, what Ms. Cannon reported is consistent with the results of a vasectomized male. So it's really not fair for defense to harp on Mr. Harrison's misunderstanding in that regard. We acknowledge he was wrong about that, but that just wouldn't have affected the outcome of the trial, because they wouldn't have been able to rebut that the state's evidence was still consistent with that medical procedure.
Sir, please step outside the courtroom with your phone or turn it off.
So next, I want to address the theory that perhaps the semen came from a family pet, a dog. It's important, there's a lot of briefing on this, a lot of facts, but it's important to note that Ms. Cross, who came up with this theory, in her own report says she could not take a definitive position that that is in fact what happened. And there's a case by this court, Davis, that's cited in the state's brief, where it in turn has a string cite of cases saying if the defense's expert cannot take a definitive position in opposition to the state's proof, we will not find prejudice on an ineffective assistance of counsel claim. And so I think that alone is enough to put that aside. We also had Agent Asbury from the TBI who also came and provided extensive testimony refuting that theory. But moving to the cell phone evidence, and Your Honors, I am focusing kind of on the prejudice analysis. I think that's kind of what defense counsel focused on, so that's what I'm limiting my argument to, but feel free to interject with other questions. The cell phone evidence, another thing I want to correct in what I thought I heard said this morning was that the state's proof at trial suggested that the defendant was the only one that had the ability to wipe the phones at trial. That is absolutely not true. On cross-examination, the trial counsel, Mr. Harrison, was able to get the state's forensic, digital forensic expert, Mr. Smithard, I think was the name, to admit on the stand that he did not know who wiped the phones. He did not know that, and he admitted that at trial. And that's because anyone with the Apple ID or password would have been able to log in from any device. And yes, Judge Easter, at trial, it was not presented to the jury as to exactly when that happened. And I acknowledge that. That is an additional piece of evidence that we have at the motion for new trial stage, but that still doesn't tell us who did it. Anybody could have done it. And yes, Mr. Richards' personal devices were taken at the time that his phone was wiped, but that's not to say that he couldn't have gone to a public library to do it, or asked his friend who was watching the victim at his house to do it, or there was an older sister that was involved that I think the testimony was that she would have also had access to the Apple ID and password. So the new evidence that we have really doesn't tell us much. The jury and the trial judge understood this. He heard all of this evidence at the motion for new trial, and he said this is just still not enough to say that it reasonably affected the outcome of the trial. There's also, and again, the record will speak for itself. There was some suggestions in the briefing that the state made it sound like the defendant was the administrator on the account. And there's a lot of transcripts Your Honor will be able to review. I was using my Control F, looking for every instance. I thoroughly read the transcripts of every time it mentioned the administrator. And I cannot find an instance where a state witness testified that the defendant was the administrator on the account. It seems like there was a video played at some point during the trial where the defendant's talking to a detective, and the defendant may have said something about being the administrator, or that the administrator had the ability to stop someone from turning their GPS locator off, or something to that effect. And I think that some of the statements the prosecutor makes later on are in reference to that statement by the defendant in his own interview with the police. So that's my understanding of the extent of that testimony, but I don't think the testimony at trial was misleading in any way with respect to the cell phone evidence. And finally, I just want to address, returning to the Brady claim a little bit. I've kind of made my prejudice arguments, but I did want to emphasize that I do not think that the state had a duty under Brady to discover or disclose evidence from uninvolved government agencies such as DCS with respect to the victims' mental health records, or even with respect to the TBI investigation, because I referenced the Sixth Circuit decision in Sutton, and I just encourage your honors to take a close look at that case, because the Sixth Circuit makes a distinction between a law enforcement agency like the TBI in that very case. If there's no proof that the people actually doing the investigating also were involved in the prosecution, then there's just not case law out there that extends Brady that far. Because that would essentially impute to the prosecution knowledge of, again, like an uninvolved government actor who just happens to be in a law enforcement agency. And
Back just a little bit, you're relying on a report from a forensic analyst, and you don't think the state is obliged to know whether or not that individual is involved in misconduct?
not when she was not acting on the government's behalf in the case. She resigned before this case.
But she was acting on the government's behalf in this case by conducting the analysis and subsequently giving that analysis in the form of a report upon which the state relied to obtain the conviction of the defendant. I guess I'm just pushing back a little
No,
bit.
that's
'cause just-
perfectly fine, Your
There's
Honor.
no difference between a medical examiner, which we have lots of cases involving medical examiners, when the state relies on, I'm sorry, you're out of time, but I just don't see that as a very persuasive argument. I do understand the other aspects of your timeline, but go ahead and respond to that.
If I could respond,
Yes,
Your Honor.
go ahead.
The argument I made in my brief is that she was not acting on the government's behalf in the case because she resigned before the case was initiated. She was involved in the investigation. And to the extent that, Your Honor...
You're not addressing the fact that they relied on her report.
Oh, I acknowledge that they relied on her report.
Okay, I must have misunderstood you by your emphasis on the fact that she resigned before trial. I guess I'm just not
So the
getting
duty
this.
to discover and disclose exculpatory evidence on behalf of the prosecution only attaches, and the exculpatory evidence here is the TBI investigative file, not her forensic report. I don't know if that's what's causing the confusion. But the last thing I'll just say about this, if I may, Your Honor, is that in prepping for oral argument, I did come across a Ninth Circuit case from 2013, United States versus Olson, 704 F. 3rd, 1172. And this actually came up in that case. There was a forensic scientist who had been investigated internally, and the court decided that that was a complex issue and decided not to reach the issue of whether the state had a duty under that.
That was a what issue?
It was a complex issue, and they didn't address the issue of whether the state had a duty under Brady to disclose that because they found it wasn't material, and that's an option that this court could take in this case based on my prejudice analysis that I laid out earlier, if you disagreed with us on the duty to disclose. But thank you for your time, Your Honors. If there's no further questions, we ask this court to affirm the judgments below.
Thank you, General Groves. You were going to handle the rebuttal?
I will. Good morning.
Good morning.
I believe we reserved 5 minutes of time for rebuttal. I'm always a little greedy. I think we also didn't use all of our initial time, but we'll see where I go and if the court indulges me based on our arguments and the questions. Let me start with the DNA, because I want to clean up some of this analysis here. And because I still think that there is some confusion in the way in which it's being described. In this particular case, Amory Cannon testified in a very misleading way, and I'm going to direct the court to the very first expert report prepared by Catherine Cross. Her reports, she did multiple reports in this case. First was a review of the TBI forensic analysis report that Amory Cannon prepared. I often call those summary reports because they don't have the underlying case notes and lab data, but the summary report. And so the summary report is what was introduced in the evidence at trial. It's what the state relied on. It's the testing that she did, I believe, if I recall correctly, around 2017, a couple years before trial. And that summary report was reviewed by Catherine Cross, and then Catherine Cross also reviewed the trial testimony of Amory Cannon. And in that first report, Catherine Cross excerpts out some of the trial testimony of Amory Cannon and says this is scientifically misleading. Number one, she's saying that she did a confirmatory test for semen when it was a P30 presumptive test. And so she's improperly testifying that this is actually semen. Number two, what she is saying is that there conclusively was David Richards' DNA found, but the way the question is asked by the prosecutor and then her response to it is she leaves it, the prosecutor able to argue forcibly in closing argument, that's his semen on her bed, that's his DNA. Because she says, I conclusively find that's his semen, and that is his DNA. And they don't clean up the difference between sperm fraction, non-sperm fraction. Anyone who's skilled in DNA, and trial counsel here admitted that he was not. He had never hired a DNA expert. He had never consulted with a DNA expert. The last DNA case he had, he said, was when he was an assistant DA in the mid-'90s. And he just didn't understand. And in the hands of a skilled cross-examiner who, as the U.S. Supreme Court has said in Hinton versus Alabama, if you don't understand science, if you don't understand the technical details, you get someone who can explain it to you and educate you, because it's your duty to go into those facts. In the hands of a skilled cross-examiner, that distinction makes all the difference in the world. And so when you couple that, the misleading DNA evidence, then with Amory Cannon's own misconduct at the TBI, I really don't get the state's argument here about how this isn't material or how they had no duty to disclose it. I don't get it at all. Amory Cannon was with the TBI as a forensic scientist at the time that she did this analysis for the state. The state relied on that evidence. The state then put her on the stand to testify at trial. It doesn't matter that at the time she testified at trial, she had already resigned from the TBI. They were still using her as a witness and relying on the work that she did when she was with the TBI. And it doesn't matter that her misconduct with the TBI, that the TBI found pursuant to its internal investigation, was roughly a year after she did the DNA analysis in this case. Admittedly, when you pour through those TBI records and analyze them, and that's what Ms. Cross did, I put her on really as a summary witness, as someone who is a lab director and can analyze the underlying personnel files and what they look like. She was able to say the TBI didn't go back that far. They didn't look at every single thing that Amory Cannon had done. They knew that she had been falsifying her time records. They knew she'd been putting incorrect dates on lab reports. When they went and they looked at their own internal time card system and the cameras at the TBI crime lab, they were able to establish she didn't even go to work those days. And rather than dig deeper and look at all of her cases and retest all of her evidence that she had tested, they didn't do that. Admittedly, they didn't do that. They wrote a letter, and it's a pretty damning letter that says, from the TBI director, your credibility is now impaired to testify in any case. And she resigned in lieu of being terminated. And I don't see how any of that is not information that a jury should have had before it when it was determining the credibility of this. And this is what it is. It's opinion testimony. And they had to determine the credibility of that opinion testimony. I'm out of time on the rebuttal time. Would the court allow me to address briefly the electronic evidence? Because I think that's important too.
That's fine, yeah.
Thank you. So on the electronic evidence, and with respect to the cell phones, so counsel for the state argued that they could not find this administrator issue from a witness who testified. And so Captain Smithhart was the Knox County Sheriff's Office forensic examiner who examined these phones. He didn't do a celebrite examination of the phones. Ms. Hammond talked about that, and that's in our brief. He just turned them on. They looked like they'd been already wiped, turned them back off, put them into evidence, didn't look at them again. Didn't examine to dig deeper as to whether or not they had ever been, how they'd been wiped. Trial counsel didn't know anything about phones. He didn't even know to get an expert to, consult with to say, okay, let's establish the timeline of when they were wiped and compare that to the other evidence in the case, because that could be important. He didn't know to do that. And so none of these decisions by trial counsel were protected by strategic decisions, because, as the court's aware, a strategic decision has to be based upon a thorough investigation of the facts and the law, so you can then make that strategic decision. A strategic decision that's not based on that underlying investigation into the facts and the law gets no difference whatsoever. So with respect to the phones here, he didn't know to do that. And when the phones were analyzed later, we now have the specific times that they were both wiped. And at trial, the prosecutor argued clearly, forcibly, David Richards had control of the phones. David Richards was the administrator. David Richards wiped them. And he argued it so forcibly to the trial court when they're talking about jury instructions. The trial court gave him an adverse inference jury instruction, which was damning to David Richards in this case, particularly when you take a look at, you had David Richards' testimony, you had Amber Richards' testimony. David Richards consistently has said, I didn't do this. You had Amber Richards' testimony, and the jury didn't get to hear the issues concerning her psychosis, her prior unfounded claims that she had made before. The jury didn't get to hear the DNA evidence and really what it meant. The jury did not get to hear the cell phone evidence. For all those reasons, we ask this court to reverse this case, send this back down to the trial court, allow a jury to be empowered with all the information in this case so they can then make the correct decision about this case. Give Mr. Richards a fair trial that he has not had yet. Thank you.
All right, thank you, Counselor. Appreciate the arguments from both sides and the briefs, and we'll take it under advisement. We've got one more case. We're going to take about a 10-minute recess and then come back and conclude the docket.
All rise. This court is now in recess.
Good job.